In this subunit, we're going to discuss the topic of anticipatory repudiation, also known as anticipatory breach. All right, here's our setup. We're going to talk about anticipatory repudiation. Now, what is anticipatory repudiation? Well, it's simply this. When two parties enter into a contract and before performance is due, and we'll just call that law day. We'll keep referring to the time performance is due as law day. So before law day, one party says, I will not perform under the contract, right? That is anticipatory repudiation. That is what we call repudiation, which is a breach before law day, anticipatory. So in this short subunit, we're going to talk about what constitutes anticipatory repudiation. It's not that hard. And then we're going to talk about the aggrieved party, the non-breaching party. What is that party's rights? May she immediately sue before breach, even though law day has not arrived yet? Can she go out and find substitute performance? May the repudiating party retract her repudiation, say, I changed my mind. What if there's some doubt? Instead of an anticipatory repudiation, you have some doubt that the other party will not be able to perform. What can you do in that circumstance? Okay, so what's the standard or test for what is an anticipatory repudiation? Well, here's the rule. If a party makes a positive statement that indicates she will commit a material breach of her contractual obligations, or she engages in some other voluntary act that will make her unable to perform her contractual obligations without a material breach, the other party, the aggrieved party, the non-breaching party, may treat it as a material breach by canceling the contract and suing immediately and or finding substitute performance. That rule is pretty clear. The idea is that if one of the parties says, I will not or cannot perform before law day, the non-breaching party, the aggrieved party, gets to cancel the contract, immediately sue for breach, and or find substitute performance. Now, there's a couple things that I want to look at here. It says if a party makes a positive statement that indicates she will commit a material breach, or she engages some sort of voluntary act, right, that will make her unable to perform her contractual obligations without a material breach. So first, let's talk about a positive statement. The statement has to be unequivocal, right? It can't be equivocal. It must be unequivocal, saying, I will not or I cannot perform, okay? If a party says, I'm not sure if I'll be able to perform, that is not an unequivocal statement. That is not a positive statement. That is not an anticipatory repudiation. Now, maybe she engages in some other voluntary act. So for example, if I promise to sell a house to you and then before law day, I transfer the house to someone else, that is a voluntary act that will make it impossible for me to perform the contract without a material breach, right? I am definitely going to be in material breach of the contract when law day comes. So it has to be a voluntary act. If I become insolvent and because of my insolvency, you are now worried that I will not be able to perform, it's not an anticipatory repudiation on my part because insolvency is not a voluntary act. All right, so let's just look at this example and hopefully it'll make sense why I'm giving this example to you. So seller to buyer in a contract for the sale of the house. Seller says, I will deliver the house 1 day late. Is that an unequivocal statement? Yes, it's an unequivocal statement. Is it an unequivocal statement that I will breach? Yes, I'm going to be a day late. I promised to deliver it on law day, and I'm going to be 1 day late. So it is a breach, but it's a minor breach, right? So it's not a material breach. So anticipatory repudiation must be an unequivocal statement that you will commit a material breach, not a minor breach. All right, moving on now. What are the rights of the non-breacher? This is pretty easy. We've already kind of gone through it. May the aggrieved party, the non-breaching party, immediately sue for breach or find substitute performance, right? It used to be way back before we developed this concept of anticipatory repudiation, hundreds of years ago, that if a party said, I will not perform on law day, the other party had to wait until law day to see if you would perform or not. Under anticipatory repudiation, if one party makes an unequivocal statement that she will not or cannot perform, right, that she will commit a material breach, the aggrieved party can immediately sue for breach and find substitute performance. All right, moving on. Can the anticipatory repudiating party, boy, that's very wordy, can the repudiating party retract her repudiation? If she said, I will not or I cannot perform, can she a day later say, ooh, I regret that, I will perform under the contract? What is the rule? And the rule is pretty simple, right? It depends on what the non-breaching party has done. If the non-breaching party has done nothing in the interim, right? We have the repudiating party says, I will not perform under this contract. And then a day passes and the non-breaching party has done nothing. And then the repudiating party says, I changed my mind. Clearly, that retraction is valid. But if the repudiating party has done any of these things, if the non-repudiating party has done any of these things, then the repudiating party may not retract her repudiation. So if the non-breaching party, the non-repudiating party has already sued, then the repudiating party may not retract her repudiation. If the non-repudiating party has already changed her position in some way, she's gone out and found another supplier, she's gone out and bought another house, whatever it is, she's found substitute performance. If she changed her position in a material way, then the repudiating party may not retract her repudiation. And if the non-repudiating party just simply says, okay, I consider our relationship at an end, I am canceling this contract, I consider your anticipatory repudiation to be a repudiation, then the repudiating party may no longer retract her repudiation. Finally, let's talk about a situation where there is some doubt about whether the other party will be able to perform under the contract, right? This is not a situation where the party says, I will not perform under the contract. This is not a situation where the party says, I cannot perform under the contract. Or it's not a situation where the party has done some sort of voluntary act that will make her performance impossible under the contract. This is a situation where you say, I think I have reasonable grounds to believe that that other party is going to commit a material breach. All right, so this is the rule. If you have reasonable grounds to believe that the other party will not be able to perform or cannot perform, right, a material breach, you can demand reasonable assurances. So you can't walk away from the contract immediately. You cannot sue immediately. What can you do? You can send a request, actually a demand for reasonable assurances. Now, you send the demand for reasonable assurances to the other party, and if you have reasonable grounds to believe that they will not or cannot perform, they must respond to you. They must give you those reasonable assurances. If they do not give you those reasonable assurances, then they are now in anticipatory repudiation. So if I have reasonable grounds to believe that you will not or cannot perform the contract, even though you haven't said anything like that yet, what type of reasonable assurances might I ask from you? Well, I might ask simply for a written confirmation. I might say, hey, I hear you're having trouble meeting your obligations under your other contracts. Please confirm with me that you will be able to meet your obligations under our contract, right? That is a reasonable assurance. I might request a meeting and say, listen, I've heard this, or because of these reasons, I have reasonable grounds to believe that you will not or cannot perform. Let's have a meeting and let's talk about it. You might ask for an inspection. I hear that because of the flood that you're going to be delayed and your delay is going to be very long, or because of this or because of that. I would like to go and inspect your premises. Or if it's simply that I hear that your factory is not functioning well, and because of that, that you're going to be late in deliveries, and I say, listen, can I come and inspect your premises? That might be a reasonable assurance that I can ask for. Or maybe I am so worried and my grounds are so strong that I can ask for you to take out some sort of bond, which is an insurance effectively on your performance. Or I might ask you to find a guarantor to guarantee your performance under the contract. Okay? Which one of these can I ask for? Well, it really depends on the situation. I don't want to ask for too much. If I ask for too much, then you have a right to reject that. You can say, if I say, listen, I have reasonable grounds to believe that you're going to be delayed and it's going to be a material breach, and then I ask for a bond or guarantee, and the court might say, no, no, you asked for too much in that circumstance. But remember, if I do have reasonable grounds to believe that the other party will not or cannot perform, I can ask for reasonable assurances. And if what I ask for is reasonable, if the other party doesn't provide that to me, then the other party is now in anticipatory repudiation. So the question is always, was I justified in demanding the assurance? Did I have reasonable grounds to believe that you would not be able to perform? And was the assurance that I asked for reasonable under the circumstances? Did I ask for a bond or a guarantee, and maybe I should have only asked for a written confirmation under these circumstances?